Senator Rafferty, we are live.
Good morning, ladies and gentlemen. Welcome to the Maine State Legislature's meeting this morning with the Committee of Education Committee and Cultural Affairs. My name is Joe Rafferty. I am the Senate Chair representing Senate District 34 down in York County. This morning, we basically have some work to do relative to a couple of language reviews and then some continued language around some of the bills 1727 and a bill relative to CDS that doesn't actually have a number yet. But in any case, thank you for being with us and sharing part of your day. I will give the committee members an opportunity to introduce themselves this morning. And I'll start with my House Chair, Representative Brennan.
Good morning. Thank you, Senator Rafferty. My name is Michael Brennan, and I represent District 36, which is part of Portland.
Thank you. And Senator Woodson.
Dave Woodson, Senate District 33 in northwestern York County.
And that sounded like a call to order, but Senator Crockett, I'm sorry, Representative Crockett.
Thank you, Mr. Chair, and thank you for the promotion. Representative Ed Crockett from District 43, which is part of Portland and part of Falmouth.
Thank you. Representative Dodge.
Thank you, Mr. Chair. I'm Jan Dodge, House District 97, Belfast, Northport, and Waldo. Good morning, everyone.
Thank you. Representative Lyman.
Good morning, Sheila Lyman, District 74, which is Jay, Livermore Falls, and part of Leeds. Thank you.
Thank you. Representative McRae.
Yes, good morning, folks. I'm Representative Dave McRae. Oh, and thank you, Mr. Chair. Anyway, I'm Dave McRae. I am sitting just outside the Education Committee room in the chair's office, kind of stranded in Augusta. I represent the people of District 148 up in the county, and as I understand it, I probably should tread water down here for a while because it's not good weather up there. Have a good day.
Thank you. Representative Lyman.
Yes, I apologize. I think I may have said Leeds. That's where I taught for 36 years. I meant part of Livermore. Just wanted to apologize.
And I'm sure part of your mind and heart is still in Leeds as well. But thank you. Representative Millett. And apparently she's not here. Currently, Representative Roach.
Good morning, everyone. Representative Tim Roach, representing District 7, Wells. Thanks.
Thank you. Representative Salisbury is not with us currently. Representative Sampson.
Thank you, Mr. Chair. I'm Heidi Sampson, representing the people of House District 21, Alfred, Limerick, Shapley, Newfield, and Parsonsfield.
Thank you. Representative Stearns.
Good morning. My name is Paul Stearns. I represent House District 119 in Piscataquis County.
Thank you. And we also have our committee clerk, Eli Murphy. Eli will help coordinate our technology this morning. And we also have our committee analyst, Hillary Risler. Morning, Hillary. And Hillary will guide us through a lot of the language and make sure that we have everything lined up as we move through our morning. With that said, we do have some language reviews. And if you would be, I'll give you the floor, Hillary. Thank you.
Thank you. I have them in numerical order. So if it's all right, that's just the order I'm going to go through. So I'm going to start with LD 176, which is an act to facilitate a grade 9 to 16 school project. And this language review is not final yet, but I'm bringing it to the committee's attention because Representative Stearns, and through some discussions with the department and with the MACD stakeholders and with the affected school districts, had offered up a potential minor revision to one section specifically regarding the CTE centers that may ultimately be affected if these school districts move forward with the grade 9 to 16 project. And I did send this out via email, and it's right here in the red language and red text. And it would add that the State Board of Education shall include all affected school administrative units and career and technical education regions and centers that have career and technical education affected by this act in the planning and approval process. So I want to make sure if everybody on the committee, because I believe this was a unanimous report, is comfortable with that and feels that is consistent with your intent, then I can move forward, including that as is. If anybody is uncomfortable or objects to that language being added, then I would recommend that the committee may want to actually do a reconsideration to determine whether to add it. I had not heard any objections over email yet, but I wanted to make sure I heard from everybody here and make sure that everyone's fine with that addition.
And I'm not seeing any questions or any hands up, so I'll give that as a nod of approval.
All right, so I will keep processing that one, and you will see that again final before it gets reported out.
Thank you.
Next up is going to be LD 1389, which I just sent you this morning. This is the bill on the Ocean School. And can you see my LD 1389?
Yes.
Okay, I apologize. I'm in a colleague's office right now, so everything's set up a little bit differently for today. So this is LD 1389. Most of this you've seen before. It provides that the powers and duties of the Ocean School would terminate 90 days after the adjournment of the first regular session of the 131st legislature. And then most of this language you have already seen regarding the transition of the school to an educational program-based model, that they developed a new funding model, a new supervisory model, and design the program to operate regionally and accept students at the program's physical location and through remote, virtual, or distance-based learning. The main revision from the last time we looked at this is a little bit more permissiveness and flexibility on subsection 4 here. It's amended to provide that they shall endeavor to identify potential grant funding for which the program may be eligible and any other funding to support the new program from federal and private sources, because there was the concern about actually requiring them to apply for things they may not be eligible for. And then of course the school is required to submit a report next session by January 15th, 2023 to finalize this transition, and that the committee may report out legislation to the 131st legislature in 2023.
Any questions, folks, relative to the language recommendations for 1389? Representative Dodge.
Thank you, Mr. Chair. Ms. Risler, can you remind me of the funding calendar as far as the change from a charter school? Nope. We're leaving the current funding mechanism, but there is a transition, I assume, as far as budgeting for the local school district that may or may not adopt them in their fold as an education program base.
So this amendment is not making any changes to the current funding mechanisms for either the main Ocean School or for any of the surrounding districts. This is requiring them to come up and determine, so if that agreement is made, and I don't remember which school district it is, but if that agreement goes forward, obviously that funding would be part of the discussion and would be part of the report that comes back in January to determine how that may work or how that may need to change. But this amendment does not make any changes to the status quo right now.
Okay, and the statute as written, the funding responsibility for them to receive funds that they have received in the past ends at the end of the first session of the 131st.
90 days after adjournment of the 131st.
Yes, thank you very much.
Yep.
Any other questions, folks? Not seeing any, Hillary. Thank you. So it looks like the language for 1389 regarding the Ocean School looks good.
I was not going to pull up the next one, which is 1807, which is an act to expand nursing education programs. That amendment solely incorporated the fiscal note, which solely reflected the appropriation in the original bill. So I'm assuming there's no questions there, and I will move on. LD 1880 is going to be next. This is a preliminary, excuse me, a preliminary language review. This is the act to provide textbook cost assistance for high school students enrolled in early college courses. And this committee amendment would replace the bill with a resolve directing the Department of Education to convene a stakeholder group to study access to early college programs. The amendment adds an emergency preamble. And there were just sort of a long list of components in this one. So I just wanted to make sure I got it back in front of the committee early in case there's anything that I missed or didn't quite capture correctly. But it provides that the department shall convene the stakeholder group in collaboration with the Maine Community College System and the University of Maine system to study a comprehensive approach on equity and access to the state's early college programs. The stakeholder group would make findings and recommendations in accordance with the following: establishing a state standard for dual enrollment certification, improving access to navigational support for high school students, increasing how and when colleges accept credits taken through early college programs, how the distribution of available funding to not more than 10% of the total funding available to the department for post-secondary education may be used for secondary students to take post-secondary courses during the summer term pursuant to Title 28, Section 4776. And I think I'm missing a word right there. It should be, and how that may limit or be a barrier to equitable access for students. The current credit limit per semester, the eligible student population who may access courses and who receives or who should receive any priority for limited spots, the cost of textbooks, and to consider any other recommendations of the state's public higher education and dual enrollment stakeholder group in their report on statewide dual enrollment equity and policy, expected to be published in April of 2022. And I put a catch-all at the end, any other areas that affect equity and access to early college programs in the state. Department of Education, in collaboration with Community College University Maine system, is required to submit a report to the committee no later than February 1st of 2023. The report must include, but is not limited to, any recommendations pursuant to the study, any suggested legislation that would improve the state's early college programs. And the committee may report out legislation related to the report to the 131st legislature in 2023. And again, this does have the emergency preamble. Is there anything missing or needing to be corrected on 1880? This one you again would see again. So if you think of something tomorrow, that's not too late. Let me know, reach out.
Representative Dodge.
Thank you, Mr. Chair. And my apologies, Hillary, if this is too nitpicky, but I seem to recall there was quite a bit of discussion about the fact that in many of the classes, they aren't textbooks, they're computer programs and other instructional materials. Is textbooks broad enough to cover that with the catch-all that you put at the end? Thank you.
No, I think if everyone's comfortable with that, I think that's a good catch, and it probably should be textbooks, license fees, or any other required course materials. I will add that in, as long as everyone seems to be nodding in agreement that that should be included.
Thank you. I see some head waving, some thumbs up.
Okay.
Representative Brennan.
Thank you. Ms. Whistler, and why is the emergency preamble? Why is it needed or on it?
It's because I asked and everyone said, yeah, put it on it. I think it's really just about getting the getting it going as early as possible. But if the committee would prefer to not have the emergency preamble, we can take it off. It's up to the committee.
Okay, well, we might come back to that.
It could also, of course, be, it's relatively easy to strip on the floor if that's needed as well. All right, next up is going to be LD 1933. And this is the Department of Education's major substantive rule on chapter 115, which is teacher credentialing. We had a very long conversation previous where the committee ultimately decided not to reconsider. And so this reflects those original conversations. It provides that final adoption of chapter 115 is only authorized if the following changes are made. The changes include that cross-reference to the pre-service candidate standards, or the initial teacher standards 10+1 is what they refer to them, but officially they are the pre-service candidate standards found in the State Board of Education Rule Chapter 114. The rule must be amended in Part 1, Section 6, Subsection 5, certification, in the portion regarding eligibility, to remove the provision that an applicant is eligible to be an educational technician 2 or 3 if the applicant has successfully completed a program in the state for approved targeting essential skills and knowledge for performing permitted responsibilities. That's the one that the committee then provided some separate language in LD 1207 regarding the specific program at Eastern Maine Community College. That will be ready for language review hopefully next week. And then the rule must be amended in Part 2, Section 1 for the school health and physical education to remove school health and just be teacher of health and physical education. And then the rule must be amended in Part 2, Subsection 2 for the endorsement 282, teacher of children with disabilities, to reinstate the grade levels for the endorsement as birth to school age 5, kindergarten through grade 8, and grade 7 through 12. And for the birth to school age 5 grade level, differentiate and specify the semester hours and early childhood and early intervention coursework necessary for the endorsement, and clarify the permissible student teacher settings. And then last but not least, just make any necessary grammatical formatting punctuation as necessary. Fiscal note simply indicates that any additional costs can be absorbed.
Any questions, folks, relative to LD 1933? Seeing none, Hillary, it appears we have approval there as well.
All right, so next one up is going to be LD 1935. I'm actually going to start with the minority report because that is a little bit simpler in this case. This is the department's major substantive rules on the school air quality standards, and it amended Rule Chapter 60, 61, and Chapter 125. This was the rule where the Department of Education had not held their public hearing over the course of the rulemaking process. So the minority report of the committee provides that because the Department of Education and State Board of Education did not hold a public hearing as required pursuant to Maine Revised Statutes, Title 5, Section 8052, Subsection 1, which is the APA rulemaking requirements, that final adoption of these 3 rules is not authorized. And since it's not authorized, there's no fiscal note associated with the minority amendment. Are there any questions on that?
I'm not seeing any.
Okay. The majority report is the flip side of that. The majority report provides that, notwithstanding that the Department of Education and State Board of Education did not hold a public hearing as required pursuant to that same section, that final adoption is authorized. However, this has been flagged as a potential unfunded state mandate. And those of you who remember this from last session, I'm actually going to pull up the majority amendment from LD 705, which was the bill that directed the Department of Education to go make these particular rule changes. And at that time, that bill had also been flagged as a potential unfunded mandate. And the committee had felt that that was, you as a committee, or majority of the committee had decided you didn't feel that was correct. And so you had instructed my colleague last session to include in the majority report summary, here we go, that the amendment incorporates fiscal note, and that the fiscal note states that to the extent that the newly defined air quality standards require some schools to upgrade their existing systems or install new systems, expenditure of local revenue may be required. And as a result, the fiscal note flags the resolve as a potential mandate. That the committee reviewed the fiscal note and the majority of the committee determined that the requirements of the resolve do not amount to a mandate. That the department rules already require that rooms used for instructional purposes have sufficient air changes to produce healthful conditions and to avoid odors or concentrations of toxic substances or dust particles. They also state that if the heating, ventilation, and air conditioning systems are mechanically driven, they shall be maintained in compliance with HVAC regulations and rules. The committee notes that the resolve merely directs the department to amend its rules to require standards governing air quality. In other words, the resolve requires the department to better define standards, but the requirement that systems be maintained in compliance with HVAC rules and regulations already exists. And as such, the majority of the committee at that time believes it is not a new requirement and therefore not a mandate. So I raise that because the question from the committee is, or for the majority, those on the majority report. As you know, we've gone through mandates many times. Options include funding the mandate at 90%, providing a mandate preamble, or you could mirror the language that you used in that resolve last year, indicating that you believe that this is not a mandate, and that would be added to the summary as you did last year.
Any questions on that? I know for myself, I would prefer to just use the same language to state that a case that it wasn't a mandate. Any
Seems
objections
like
to that? Or any questions about that? I'm not seeing any, Hillary, so.
Great. I'll draft that up. I will send it to you via email before it gets reported out, just to make sure it matches with your intentions. The only thing, as with last year, I would remind the committee is that even once you put that on, the bill still would likely go to the special appropriations table. And so committee members, to the extent you want to move it forward, will need to speak to those on AFA regarding how you want to move it forward.
So would they approach us first, or do we approach them first?
I don't really know. I've been not being involved in any of that, but I suspect that you would need to approach them.
Okay, thank you.
Okay. Next up is 1963. This will be very brief. So this is the Education Stabilization Fund. And this was just amending this language to mirror that which was provided in the supplemental budget. So that language is the same, except for as with you recommended on the supplemental budget, making this transfer for payments included in the statutory provisions. And then it also provides for the transfer of the 30 million, and the fiscal note reflects that 30 million transfer.
Any questions? Representative Dodge.
I'm starting out the day in a fog. I am going backwards, if I may, Mr. Chair.
Yeah.
Thank you. On the air quality standards, and this really isn't, I don't think for you, Hillary, it's probably for the department. But if we run into a problem on that bill, do you recall if we have information or tabulation on school districts that have applied their recovery funds and federal funds to attempt to achieve ASHRAE air quality standards, so that we have some information from which to work if we run into a problem? And we don't need to talk about that now, maybe, but I just raised that as a question. Thank you.
Yeah, I do think the department had provided some, I don't know if they had the number of districts, but they certainly had some numbers about how many districts had and were planning on using federal funds for these. The only, I can see if I can locate that for you, or if not, I can see if the department can get you that information. But I do recall that as well from the discussion on them.
But we may not need it, right? If there's no problem with the language in the bill, with a fiscal note and all of that, we may not need it.
Yeah, I couldn't, I mean, I don't think I'm in a position to answer that.
Thank you. Thank you, Mr. Chair.
Yeah.
You. So, 1963, where,
So now we're going to go to 1989. And this is the Representative Carlo's bill on the lease. And there was just a lot of discussion about what exactly needs to be included. And so I really just wanted to make sure before this went any further that I captured the intent. So this makes the technical changes, which is that it narrows the scope of the exception specifically to that paragraph that has to do with the 4 years. It amends the name to match the certificate of organization. It corrects the address of the property. And then my understanding of where the committee landed was that they may only enter into this lease so long as the lease addresses the terms of withdrawal from the lease by either party. Is that everyone's understanding as well?
it's my
Seeing a thumbs up.
recall. I see some
Okay.
thumbs up. That's good.
Great, okay.
Good questions.
Then in that case, that is everything for language review that I have at this moment, other than, of course, the CDS and 1727.
Okay. Very good. So let's take a look at 1727. And just for a heads up, I know that there was some confusion in terms of language and so forth, and I know there were some discussions continued relative to language, just for clarification. So at some point, I know that in terms of our intent and language matching, I may ask for some assistance relative. I know Hillary has a lot of it, and I think I might need a little bit from Carolyn Russo, who worked with the folks from both the university as well as the sponsor, President Jackson, just so the language was what all parties had. We did a lot of verbal agreements. They just wanted to match the language with those agreements. So, Hillary?
So if it works for the committee, what I think might be helpful is if I could first go through the minority report, since that's going to be, I think, a little bit simpler and a little bit shorter of a conversation. And then, as I mentioned to the committee when we worked this last, I also had a number of questions and drafting considerations where I wasn't sure exactly what the intent was. And so I think perhaps what we could do is, after I go through the minority report, go through my version of the majority report. And when I sent that out to the committee, there were a number of pieces that I had put in red text where I had some questions, and I'll go through and explain what my questions or what my request for clarification is on each of those sections. Some of those you may be able to answer relatively quickly. Some of those, it might make sense for me to just explain, and then you may want to take a break or take a caucus to provide whatever answer it is for clarification that is needed. And then it has come to my attention that there have been some additional clarifications on parts of the language that have come out of the Senate President's office. I did receive those. I have not had the opportunity to really go through them or to match them with what I have. So we'll have to work through all of that as well, which is where I believe Ms. Carolyn Russo may be able to come in and help walk the committee through those particular aspects. Some of them may overlap with a little bit of my questions. So if it's all right with the committee, I'll start with the minority report, and then we'll dig in onto those clarifications for the majority report. The one question I had going into today on the minority report, which would be establishing a working group, was on who should be the one convening this working group. I did reach out to Representative Stearns as being on that minority report, and he suggested the higher eds. And so I asked them what would made the most sense for who should be convening, and they suggested the Public Higher Education Systems Coordinating Committee, which is the Maine system and the Maine Community College system. in consultation with Maine Maritime and the Maine Independent Colleges Association. So I did add that into the draft for review today. It provides that they have to convene, that the work group must include representatives, and I tried to name all the ones that we had been hearing from, including Title IX coordinators from the state public higher education institutions and Maine Independent Colleges Association, as well as representatives from the Every Voice Coalition, Maine Coalition Against Sexual Assault, Maine Coalition to End Domestic Violence, and any other stakeholders as appropriate. Provides that the work group shall study any legislation submitted to the 130th legislature concerning sexual misconduct on college campuses, including any amendments proposed by a sponsor of such legislation, and make findings and recommendations in accordance with the following. A, whether the proposed legislation creates any criminal or constitutional conflicts or otherwise conflicts with or could be preempted by federal law. Whether the proposed legislation raises due process concerns. To what extent the passage of such proposed legislation could create unintended consequences. Whether any current or proposed federal regulations may impact the need for or revisions to the proposed legislation. The experiences of other states that have passed similar legislation, and any potential costs or fiscal considerations associated with the proposed legislation. It provides that no later than February 1st of 2023, the work group has to submit a report of its findings and recommendations, including any suggested legislation to this committee and the Judiciary Committee, and that either committee that receives a report may report out a bill related to the report to the 131st in 2023. So for those on the minority, is there any questions, concerns, corrections? I'm seeing a thumbs up. All right, excellent. In that case, I will now shift over to the draft of the majority report. Okay. So again, this is the draft that I did based solely on the conversations and the discussions of the work session and flagging those areas that I think I still have concerns or questions about. This does not include any of the proposed revisions or clarifications that may come from the sponsor of the bill. The first question I have is here on the definition of intimate partner violence. And the question here and the issue here is that this definition is cross-referencing a lot of different things. And it's cross-referencing this definition of abuse, which is in Title 19A, Section 4002. And I'd like to bring that up quickly for you. And I do apologize, I'm going to be sort of bouncing between a couple different screen shares. I will try to do it as smoothly as I can. But this is the protection of abuse statute. And this is the definitions of the statute. And that cross-reference provides, if I can find it. Okay. Can you see that, or is it too small? Yeah, Representative Dodd says she can see it, but then I can see her leaning in. See, that helps a little bit. So abuse means the occurrence of the following acts between family or household members or dating partners, or by a family or household member or dating partner upon a minor child of a family or household member. So my concern here is when you look at these two different definitions, you're saying that abuse means this definition here in Section 4002, and yet in the draft itself, it's using a slightly different term. It's using abuse against an intimate partner. And so there seems to be a bit of a conflict internally within this definition. And then abuse is also defined in the draft as against a dating partner as defined by this same section. But this definition already includes that it's going to be a dating partner because that's part of the definition in 4002. So I'm a little concerned that it's not clear what this definition exactly is. And I think it would make sense to either cross-reference this definition in its entirety or to come up with a definition that matches what it is you intend. Additionally, the definition sort of purports to say that the abuse is defined against an intimate partner, as that term is defined in federal law, but it doesn't provide any more specificity of that. And there's a lot of federal law out there. So I'm not sure exactly what definition it's implying. I don't know for a fact there is a definition in federal law that includes intimate partner violence, or there could be more than one in different federal statutes and regulations that could create confusion or conflict. So this is a definition I do think that needs to be clarified, what the intent is, of whether it encompasses just the abuse definition as it is in 4002, or whether it should be something different. And this might be one that I just want to flag, and I can move on to the next, and at some point the committee can discuss what you want to do. And I'm seeing nods, so that will be my plan. I'm going to move on to page 6 of the draft. This is here on the confidentiality provision. And this also, I think, may be one area that Ms. Carolyn Rousset may have some clarifications as well, but I'll start with what I have. Can you see my screen? Okay. Yeah. So this confidentiality provision. So the first thing I wasn't sure of is that the rest of the section is about what the policy must include. So I had redrafted this a little bit to provide that similar to everything else in this particular section, is that the policy must provide that the identity of a reporting party and a responding party and all information relating to an incident of sexual misconduct is confidential and may not be disclosed. So this is one case where I do believe that the term sexual misconduct has mostly been stricken from this draft and needs to be replaced, as it is elsewhere, with the sexual violence, interpersonal violence, or stalking. But my bigger question is, first, this doesn't include anything about the reporting or responding party consenting to their identity. So this would say even if they wanted to consent to their identity being disclosed, that this doesn't allow for that. And it's not clear exactly who has to keep this confidential. Is it the institution? Is it the confidential resource advisor? Is it anybody who's learned of it? And I think that's where Carolyn Musso might have a suggestion that it was the institution that has to keep it confidential. But perhaps the biggest question I have is in regards to confidentiality in general and how that relates to Maine's Freedom of Access Act and public records exceptions. This currently provides that the identity and information relating to the incident is confidential and may not be disclosed except as necessary to carry out a disciplinary process or as otherwise permitted under state or federal law. My question for the committee is, do you intend, the Freedom of Access Act is state law. Would you intend for this information to be subject to a public records or to FOA? I'm guessing the response is no, that wasn't the intent. And I will say, certainly, even if it was subject to that, there may be other, for example, FERPA or other federal regulations that would keep it private. But if the intent is to have this be an exception to the public records requirement, there are certain procedural processes that the legislature requires. And this is going to come up in 2 other sections of the majority report as well. So I'm just going to stop sharing again briefly and go to Title I. So under Title I, Section 434, whenever a legislative measure containing a new public records exception is proposed, or a change that affects the accessibility of a public record is proposed, The Joint Standing Committee of the Legislature having jurisdiction over the proposal shall hold a public hearing and determine the level of support for the proposal. If there is support for the proposal among a majority of the members of the committee shall request the review committee, which is the Judiciary Committee, to review and evaluate the proposal pursuant to the list down here in section 2, which I'm not going to read through entirely. But essentially what this means is if you are creating a new public records exception, and the way this works in practice is that I would draft a memo to the Judiciary Committee on the majority report's behalf. The Judiciary Committee usually would ask one or both of the chairs to come to the Judiciary Committee to do this review and sort of explain why this is needed. And the Judiciary Committee review might then reply in a memo to the Education Committee with their thoughts or recommendations, or say it looks good, or maybe you want to think about this. Those recommendations are not binding. And obviously where we are in session, it may be unlikely that the Education Committee could even meet to consider those recommendations, but you could on the floor or anything like that. So I know most people probably weren't thinking in terms. I know I in particular wasn't thinking in terms, because when we think of these incidents of sexual misconduct, we're usually thinking FERPA and all these other privacy protections apply. But because it is putting it in statute and is making technically a statutory exception in Maine law, it really probably should be subject to this review. And I think if the intent is that it is an exception to FOA, that should be clarified in that section as well, because currently it says if state law permits it, then it's allowed. And I don't think that was the intent on that particular section.
No,
Someone want to jump in on that one?
I'm just mumbling. I believe that confidentiality standing alone is what we envision in my mind, is that a person that's been through this experience certainly is I believe would be seeking protections from freedom of information. I don't think that that's something that somebody wants shared. That's the whole idea of the word confidentiality. So we're going to have to figure out how we protect those privacy. So if we have to go through that process, what you're suggesting is a probability or a possibility. But
yeah, and there are two other provisions in the majority report that I think implicate the same process. And so what may make sense when we finish up today is if the committee directs me, probably work directly with Representative Brennan and Senator Rafferty to craft that memo and make that happen. We don't need to talk through all of those components today, but if the committee directs me to do so directly with them, that probably makes the most sense.
So Hillary, my guess is that these events are currently taking place. So there must be some built-in protections that the university already has relative to confidentiality. Does that not protect the student? I mean, do we need those further protections, I guess? I don't know.
I would have to defer that question to probably the university systems as to whether they feel like this is necessary.
Thank you. Representative Brennan has a question.
Yeah. Well, I think more of a comment. Thank you, Senator Rafferty. I would agree with you, Ms. Rizzo, that we should probably draft something, and then again, it does go for judicial review, correct?
Judiciary, yes.
Judiciary Committee would do the review, but I'm also the language, says that confidentiality would be protected, except as otherwise permitted under state or federal law. That's always been my concern, because there are state laws about mandated reporting of certain circumstances. And that's when you breach confidentiality, because state law trumps that confidentiality. So I thought with this language that covered that and said that confidentiality would be protected, except in those cases where federal or state law said that confidentiality would be breached for whatever reasons those state or federal law allowed for.
I do think that this language does cover that. I think, but FOA is also a state law. And so, for example, what you might want to add is a sentence that says, any records relating to this incident of sexual misconduct is not a public record or is confidential under the Freedom of Access Act. So it's just separating and saying it could be permitted under state law, for example, mandatory reporting or other things like that, but it's not permitted to be allowed under FOA. And that would be the clarification.
Okay.
I think you would
Okay.
need.
Representative Stearns.
Thank you, Mr. Chair. I have just a procedural question. I know that I don't believe I'm allowed to comment on the majority report because I wasn't part of that report, if I'm correct, and Hillary can let me know if that's true. But I guess my question is, when does the language review, when it starts to involve more than language and starts to get into really some deep content, is there any mechanism to speak to that? And again, I throw that out there. I'm a little uncomfortable, I guess, at this point. So I'll throw that to Hillary to be the judge and jury on what is allowable and what's the trigger for when we swap from language review to actually changing the bill.
Unfortunately, Representative Stearns, I am not the judge and jury on parliamentary procedure in this committee. It is always sort of a question of what's clarification or what is so substantial that it requires a reconsideration. I defer to the chairs of this committee to tell me when that line is, and if they tell me this was their intent, that is what I will draft. If it seems that it needs a reconsideration, then I will defer to the chairs.
Fair enough. Thank you for clarifying that for me. Yep, thanks.
The word clarifying is critical here. So we are trying to clarify, and we need the content of the bill to say so, that there is an expectation of confidentiality towards any victim of some type of abuse.
Okay, so moving on to the next question, and this one will be a little bit simpler, I believe. There are a few places where we have this sort of definition of the reporting and the responding party. They weren't always used completely consistently. So if you go to page 12 of the draft, this is one of those places where for the direct assistance, it says if requested by the student or employee. And my question is, should that just be the reporting party as that term is defined?
Well, I don't think
because the reporting party means a student or employee who reports having experienced an alleged incident, or is this meaning something different?
I suspect that your revisions have created a different numerical order of the pages. So I'm looking. Okay, I found mine on page 10, direct assistance. Okay, so I'm gonna look at directed. Okay.
So I think that probably should be reporting party, but I just wanted to confirm, and I'm seeing some head nods, so I think.
Thank you.
The next component on that same page, just the final financial resources here. It just reads a little awkward, and I just sort of want to flag two things. I don't know that I need an answer, but provides that financial resources, including if a student has to withdraw from a class or school entirely, that the institution shall provide tuition credit, opportunities to withdraw or re-enroll in a course without academic or financial penalty, and continued eligibility for scholarships and honors. And it's just, it reads a little bit awkward because if you've already withdrawn, sort of the opportunity to withdraw has probably passed. There's a little bit of a timing concern there. And then the other question or concern or flag I want to raise is, of course, there are some financial resources that are used by students, such as federal loans or outside or private loans or private scholarships, that certainly would not be under the control of the higher ed institution. And so I think you may just want to add a clarification: financial resources over which the school has control. But certainly they don't have the ability to control all of those outside resources. So if the committee is okay with me making that sort of clarification, I think that would be important.
I think that makes sense. Any objections? Thank you.
So the other question on that same page that I want to flag for the committee is here. So under additional actions, it provides that a confidential resource advisor regarding an alleged incident of sexual violence, intimate partner violence, or stalking shall notify all school staff who are involved in providing or enforcing supportive measures or accommodations of their duties. My concern with this language is that there are a number of confidentiality requirements of the confidential resource advisor. And if the confidential resource advisor is prohibited or has privilege with the student, that would need to be waived in some way or communicated in some way for them to be able to notify all school staff who are involved in providing these measures. And so there's sort of an internal conflict there, and I don't know if you address, may, similar to what paragraph B here, may, if appropriate and directed by a student, make this notification. But I'm not sure how a confidential resource advisor would make this notification when they're otherwise bound by certain confidentiality and privilege requirements.
Representative Dodge.
Thank you, Mr. Chair. Thank you, Ms. Risler. If my memory serves me correctly, I believe this discussion had to do with giving the confidential resource officer a similar pathway to support a person who has experienced sexual violence, similar responsibilities and ability as the Title IX person. Can someone help me remember if that's correct, please? And that may be where that came from.
I believe you are correct. So hypothetically, if it meant me changing a class to a different hour, or switching sections, that type of thing, that was the type of notification. It was like, okay, Joe Rafferty has to switch from Monday, Wednesday, Friday, 3 to 4 till Tuesday, Thursday, 2:30 to 4. Those types of things. But that was maintaining confidentiality, but had the ability to make those recommendations.
So my concern is how this contrasts with the confidentiality provision we just talked about, which requires that the identity of the reporting party and responding party are confidential. And the identity of the student would be needed to make these types of changes.
But what happened, it's only a request that a student be moved. It's not sharing of why. It's just when that person comes in and says, you need to move so-and-so to this group. It's not, there's no explanation as to why.
And if the committee is comfortable with that, I will leave the language as is, although I will note that if a confidential resource advisor whose sole purpose on campus is to deal with these types of incidents, if the confidential resource advisor is going to the teacher and saying the student needs to move, I think there is an implication of why.
Well, that same conversation came up when we were talking about Title IX folks.
Yeah.
And eventually, I mean, we all go in with confidence. I mean, working in my school, I see that after a number of visits by certain people, you know why they were here, so to speak. But I think that these things typically at a university, There's opportunity for more privacy for the adults to meet. And I think that I have more confidence in that, those roles are protected, and there's no requirement that that's the only responsibility of this person. This person could be in fact serving in other capacities for the school. So it's not needed that that's their sole responsibility. So they could be coming in, for another reason relative to a different part of their job description.
Okay, so we'll leave that one as is. Going on to the next one, this is under that same section. It provides that they may disclose confidential information only with the prior written consent of the student or employee who shared the information, and only if required by state or federal law. What this is doing, I think perhaps this and here should be an or, because what this says currently is that with written consent, they can only disclose the information if it is also required by state or federal law. So I believe that it was intended to be an or. You can share it with written consent or if it's required by state or federal law.
That's fine.
Okay.
Any problem with that? Anyone? I can't see everyone now, but no, I think that's
I-
only taking an and for an or, I think. Did anyone see any issue there? We're good.
I was pretty sure that that was the intent, so.
You
Okay.
go from it. Yeah, thank you.
And my next question is in the retaliation section. And there's a revision made here that it provides that if a conflict of interest arises for an institution in which a confidential resource advisor is advocating for a reporting party's need for sexual assault support services or campus or law enforcement services, the institution may not discipline, penalize, or otherwise retaliate against the confidential resource advisor for representing the interest of the reporting party. And my question here was just, I wasn't really sure exactly how the conflict of interest is what's triggering this retaliation. Where is the conflict of interest? Who is it between? Normally when you talk retaliation, it has to, I'm just not quite sure what this is getting at. And so I would need a little bit of clarification. And perhaps you all understand exactly what it's getting at and understand it perfectly, in which case I will send it on its way, but I felt that I did not exactly understand how that conflict of interest arising triggered or tied into the retaliation.
So I believe, and this is my take, this is for discussion purposes. So I believe that this is just protecting the advisor from any retaliation that, so hypothetically, I foresee this basically as job protection for that particular person. Don't retaliate because I did this. That's how I view it.
So I guess my question then is, why would it be necessary for a conflict of interest to arise to provide that protection?
I don't believe there would be, should be. I really don't. But I would have to, I agree. I just don't.
Yeah. So we could flag that one and come back to it perhaps.
I think if a person's doing their job, what I mean, that's what they've been asked or hired to do. I don't know how there would be a conflict in terms of this is what I was hired to do. And I really don't know.
Yeah.
So I'll put I can't put a red question mark because it'll blend in, but I'll put a question mark there myself.
Yeah. The next one is on privileged communications. And this is pretty straightforward. So I think when this was being redrafted, being done quickly, whoever was doing the drafting used the term victim. But again, I think we should be using reporting party because that is the defined term for the rest of the chapter. And then I would also note that since we just talked about the confidentiality and public records exceptions, there is already in law a specific exception to public records requirements for any records that would be within the scope of a privilege against discovery or against use as evidence. So although not directly related to a public records exception, this is one that I also think might be worth mentioning in your memo to judiciary, because this is creating that privilege, and any records resulting from that privilege would not be subject to FOA. And then similarly, for the confidential criminal history record information, obviously that information is already confidential. It is already an exception to public records. However, you are slightly altering who may have access to it. So you're slightly altering the exception. And so that's another piece. That's the third piece that I think would be worth mentioning in your memo to judiciary. It's pretty clear why you're doing it, and it's clear that that information, once in the hands of the confidential resource advisor, would remain confidential, but it is sort of altering slightly how that particular exception that already exists may be disseminated.
Okay.
The next one is on this cross-examination, and I had raised this in my my bill analysis, but provides that nothing in this section may be construed to limit either party's right of cross-examination of the confidential resource advisor in a criminal or civil proceeding if the confidential resource advisor testifies after written consent has been given. But then it provides that a confidential resource advisor shall not act as a counselor or therapist. And I do think that's covered earlier. Right? There's another portion that specifically says that they may not act in that capacity unless licensed and engaged in that role. I'm not sure why this is here or how this relates to cross-examination.
If it's already defined, I think that's just a duplication, my opinion, so.
So it sounds like we could probably just take that sentence out as long as it's covered in that other section.
Representative Brennan?
I could be wrong about this, and I did agree that there is another section where it says unless appropriately licensed, but also there are at times limitations on having to testify in court as a counselor or therapist in terms of confidentiality, and you are protected unless you're subpoenaed, or so I don't know if it was just added there. In the part of testifying in court, it does seem to be an awkward sentence at that particular point. But the only thing I can think of is that it may have been there because counselors and therapists, quote, are protected from testifying in court unless directly subpoenaed by the judge.
I think as long as it's clear in that other section that they are not acting in this capacity, my suggestion would be to remove it from this particular section. But if there needs to be further clarification, or there was something else that someone was getting at that needs to be there, perhaps when we get sort of to the end, we can circle back to a couple of these things and figure that one out. The next clarification that I think is, I know the answer to, but just want to confirm, is on this section here. This is the training for individuals involved in the disciplinary process, and it provides for the requirements for involvement in the disciplinary process. And the last one that was added was methods of communicating sensitively with a responding party, including an awareness of the emotional impact. And I assume that's referring to the emotional impact that an allegation against you of an incident of sexual violence or misconduct occurred. Is that correct, if that's what this is getting at? And if so, I'll just add that, because right now it just sort of says the emotional impact, but it doesn't really say the emotional impact of what. So it seems to me it's referring to that emotional impact of being accused of something.
Right.
If that's accurate. Okay. The next one was, I was not clear because when we sort of struck the oversight of the Department of Education from the draft as a whole. I couldn't remember whether we talked about on the reporting, whether you still wanted the report to go to the commissioner and the Commissioner of Health and Human Services, or if you just wanted it to go to the Education and Cultural Affairs Committee. And if you're happy with the way it is, I can just leave it as is, but I had to flag that for myself to make sure I asked.
I see a hand up, Representative Dodge. I'm trying to read it now as well.
Thank you, Mr. Chair. My notes on that were around the fact that DOE is generally pre-K to 12. And we discussed, was that appropriate? But I don't remember where we landed. Sorry.
So I guess I would ask for, at this point, do you as a committee believe that this report should go to the commissioner as well as the Commissioner of Health and Human Services, or do you think it's mostly just important to have that report come back to you as a committee?
Well, definitely come back to us.
Yes.
At a minimum. And I don't know, I guess I don't see where it would hurt to send it to those other people. I mean, it might be an added, thing in their world, but I don't think it's going to hurt to have that shared with those folks.
We will leave that as is. And then last but not least, this was something that was raised, I think, by the higher eds, and might also be something that Carolyn Russo will speak to. But on the immunity provision, it provides that a reporting party or witness who requests an investigation may not be subject to disciplinary proceeding or sanction or penalty for a violation of the institution's code of conduct related to drug, alcohol use, trespassing, or unauthorized entry, or a violation of the policies unless it was egregious. And my question for the committee was, this is sort of broad, and I'm assuming you probably intended some language in here that says they cannot be subject to these things if it occurred related to the incident that they witnessed or that they're reporting, as opposed to just a broad statement. I'm assuming you want it related to the incident that they're reporting or witnessing. Yes, okay. Okay. So those are the clarifications, such as they are, that I have on my draft as it stands right now.
Thank you. I do know that excuse me. There were some additional clarifications, again, mutually agreed with conversations with myself, as well as the university and the sponsors. So it was a definition, so to speak, a couple, but I'm going to ask then if we could, I want to make sure we hear them from one person rather than me trying to interpret. I'm going to ask that Eli, if you could bring Ms. Russo in for clarification on some of the language. I believe may have already been addressed, but we'll take I just want to be sure. Thank you. Good morning.
Good morning, Senator Rafferty.
Well, I'm not sure you were able to hear our meeting up to this point, Ms. Russo, but we went through the language review, and I just wanted to make sure that I know there was an effort to tidy up some issues that were still seemed confusing as people went to their, had a chance to read more, and I just want to make sure we're all on the same page, and if we need to make a change, so I'll make that request or recommendation.
Okay, thank you. Thank you, Chair Rafferty, for inviting me in, and Chair Brennan. My name is Carolyn Russo, for the record, and I'm a Policy and Legal Director for the Senate President's Office. And I want to just first, since I'm speaking for the Senate President's office, I really want to thank everyone who's worked so hard on this bill. It's been a bill that has been worked on for the last 2 years and included victim advocates, the people from every voice, as you know, and students, colleges and universities. And it's taken a long time. There's been a lot of coordination and cooperation. And I just want to publicly thank everybody and this committee for what they've done. So in regard to these technical changes, Samantha Warren of the University Maine System and Becky Smith from the Maine Community College System reached out to us on a Monday night and sent us some technical changes that they would like us to consider because they think it would make the implementation of this law, if it becomes law, easier for them. And so we met up with them quickly on Tuesday afternoon, and Senator Rafferty was there and Representative Brennan was there. The Senate President was there, as was Samantha Warren, Becky Smith, and myself, and the Chief of Staff in the Senate President's office. So I think Ms. Reisler has, I forwarded to her a copy. I don't know if she can share that. It might be easier if that's shared as I go down through it. And you will see that some of them are absolutely some of the things that Ms. Reisler brought up.
Hillary.
I just want to jump in. So I was CC'd on a document that I believe was only sent to those on the majority report. And if you would like me to share it at this time, I would first like to send it out to the full committee so that everybody has it.
Sure. Yeah, it was shared with them because obviously we wanted them to see those technical changes since it's their report. But yeah.
All right, I just emailed it for the sake of being the screen share of the day. I will pull that up.
Thank you.
Okay.
All right. Excuse me. Wasn't really planning on doing this. So also if there's some typos, this was done fairly quickly. But with regard to our meeting, the first change that wanted to be included is the definition of student. The university system and the Maine Community College System indicated that their definition of student that they use most often is as follows. It means an individual who is enrolled or is seeking to be enrolled in Maine post-secondary institution, who's a candidate for a degree or diploma or graduate certificate, or has taken a leave of absence as a result of having been a victim of sexual violence, intimate partner violence, or stalking. So that we'd like to change the definition that was in there. And I think the only difference with regard to that, really, even though I didn't cross it all out, was that the extension student was in the other definition. And they convinced us that that might just be some person taking something online and that it was too broad of a definition. So that's the definition. And that's that whole section. That's the only change. With section 12952, adoption of policies and related procedures. Originally, it was just adoption of policies, and they suggested that we add in related procedures in that throughout, because it's more than just the policy, there are procedures described. We are amenable to that. It just seemed like a oversight. Then subsection 1 of section 12952 discussed about where to disseminate the information of the policy, where the policy should go, where it could be available. And with discussion, they indicated like some of their policies are 24 pages long. And the original section of the bill said it should be available, and it listed a lot of places for it to be available, where it didn't really make sense that 24-page document would be available there. So this change really is just indicating that each institution of higher education shall adopt a policy on sexual violence, intimate partner violence, and stalking, referred to in this section as the policy, in accordance with this section and consistent with applicable state and federal law, and this is the change, which shall be publicly available on the campus website and in the student handbooks. Then additionally, notices of policy should be available in outreach for victims of sexual violence, partner violence and stalking must be posted on campus locations where students regularly congregate. The institution shall update the website annually. So in other words, there are notices that are up in this campus of where to go if you are a victim or who you can reach out to. So we want those notices obviously to still be out there, but not the whole 24-page policy. That made sense to us. I mean, obviously they're the people who work in the field, so they understood that better than the drafters of the bill. The second section, really it's just reflecting the fact that the ultimate authority is in the board of trustees of these organizations or governing bodies, and not with Title IX, et cetera. So they wanted that the policy reflect the diverse needs of all students and employees, which is what it originally said, and that the institution may consider input rather than must consider input from various internal and external entities, including but not limited to, and that's really the only change. And they're all listed as they were in the original, but instead of saying that they must work with the Title IX coordinator and local sexual and assault support domestic violence resource, instead it's that they may. That's really the only change, even though that looks long. It's in the next page, I think. These start getting shorter. They indicated that students, employees don't have obligations, but they do have rights, which we agreed. They wanted us to add informal resolution, which made complete sense. A summary of the institution's procedures for informal resolution, and then, because that comes before the investigation or the adjudication, et cetera. Good clarification. The next was the procedure be uniformly applied for all proceedings. They wanted us to get rid of disciplinary because, again, the process starts before it becomes disciplinary. So that made 100% sense. They asked us to strike the policy must include a clear statement advising students of the procedures of the policy. They asked us to strike all of paragraph H because disciplinary processes that pertain to employees, which is what that section deals with, vary depending on a bargaining unit. They're not all uniform. They added, as I think you might have, Hillary, in yours, the institution may not disclose the identity, which I believe is something you brought up as well. And then an effective date. No changes or concerns with notice to proceed with section 12954, higher education interpersonal violence commission. They asked that it be changed. I mean, you can scroll up a teeny bit, please, when you have the time. Note the other way. Scroll down. Oh, sorry. Basically, because they didn't have them advising the commissioner, they rather wanted to change it that this commission would be reporting back to the committee, which I think you also changed in yours already. And then in section 8, information to be gathered, we wanted to make it clear that because the Violence Against Women's Act was the reauthorization that just occurred and was just signed by President Biden, indicates that universities and colleges need to do a survey that is similar to this survey. Not exactly the same. And all, but federal law can change and also funding can stop. So we wanted to make sure that with regard to the information gathered, that the additional list that was included in the original amendment or the original bill actually was maintained, but that it was done with consideration of what the universities and colleges already are going to have to do with regard to this federal requirement. So we wanted to change that beginning and just say the interpersonal violence climate survey must collect anonymous responses, may not require the disclosure of personally identifiable information. The survey must include the survey requirements of the Violation Against Women Act Reauthorization 2022, and the commission shall, without being duplicative, be designed to gather the following information and then keep that list. My guess is, Ms. Reisler, that's not the best wording for that, but I think you probably get the gist. Thank you. And then again, under duties, changing the date. With regard to dissemination of the data and collection and reporting, just wanted to add the word aggregate before data, which makes it much more anonymous as well. We did not put anything in the confidential resource advisor section because we hadn't seen the new language and we knew that that was going to be amended. Let's see. And that's the next section on, if you can scroll. Thank you. Obviously, okay, awareness programming for this. The major change here is we didn't want to make it mandatory every year because the institution just thought that it would be they'd be overwrought with what they had to do. So we indicated that mandatory prevention and awareness, but we wanted that for incoming students. They already told us that they do that annually for employees. So mandatory for incoming students and employees, and then added that the institution shall make available awareness training to all returning students of the institution. And then it would go on to say what it includes. We believe this is important because we heard from students, many students, who said that the original, training, they get it, they're getting all these things as they're starting a new school. Things go in one ear, out the other, etc. And that it would be useful for reminders. So with regard to training, they wanted to rename the section because these individuals need to be trained. Training for Title IX coordinators, campus safety personnel, and individuals involved in the disciplinary process. With regard to immunity, this is something you brought up as well, Hillary, maybe adding at the end, or with regard to drug and alcohol use that comes to the institution's attention as part of the report or investigation, which you also brought up. And they asked us to remove paragraph A from the memorandum of understanding, which I think is something you also brought up, and to add related to sexual violence, intimate partner violence, or stalking at the end of paragraphs C and F. And then to strike paragraph D, which I want to look, and that was free transportation for mental health. Because we talked earlier in the bill about, if available, that they would provide that service. So we didn't think we needed to have it there again. And those are the technical changes that they brought forward and that the group that met was amenable to. Any questions?
Because my phone was on. Representative Brennan.
Thank you, Senator Rafferty, and thank you, Ms. Russo, for being here and walking through those changes for us. Obviously, it looks like there's a lot, but I think when all is said and done, it does make the bill better. I think it also addresses some of the issues that Ms. Risler raised, maybe not all, but some to some degree. And Senator Rafferty, I'd like to, at this point, if possible, if Samantha Warren from the university and Becky Smith from the community college is available, if we could call them in very quickly, just to hear their comments on what was just presented.
Eli can see if they're available. I don't see that. Representative Stearns?
With all due respect to the chairs, this is starting to sound an awful lot like a hearing.
Okay, that's fine. We don't need to hear from Ms. Warren or Ms. Smith at this point. And I just thank Ms. Russo for her presentation and the willingness of the sponsor of the bill to work with the interested parties, most especially the community college and university, to address some of these issues. And again, I think it strengthens the bill in total.
Thank you.
Thank you. Hillary, you all set?
I don't have anything else to add at this point. I think the only thing I would say is, to the extent we're working on clarifying the current language, I think you have the questions, and there's still some outstanding questions that I had provided. I do think some of what Carolyn Russo mentioned is actually adding or deleting or striking some of the sections. So I would look to the committee as to whether you believe that was your intent at the time of your vote or not.
I believe with the corrections of your language, I don't know if your corrections and her corrections are conflicting. I need to have that pointed out to me, but I do believe that the intent of the bill is secure. Representative Brennan?
Just thank you, Senator Rafferty. And Ms. Whistler, just to answer your question directly, yes, it does reflect the intent. And certainly there has been open discussion and commitments since this bill has been presented to continue to look at ways to refine it and to come up with compromise language, given the fact that this does touch on a number of legal issues. And I think we're fortunate to have you and Ms. Russo, who are both attorneys, be able to help us work through some of these sections. But certainly what has been put on the table at this point is reflects my intent. And again, I was pleased to be able to work with the Senate President, sponsor of the bill, to address some of these proposed amendments.
Thank you, Representative.
So I guess what I would be looking for at this stage in terms of moving forward is I think there were sort of a few outstanding questions, clarifications, concerns that I had raised, for example, on the definition of abuse. That I would still need a little bit of clarification on how the committee wants to handle that.
Well, and the outlying question also remained relative to judiciary, correct?
Right. And so I guess, as the majority of the committee, this is your amendment. If you want to say we're actually comfortable with it, we like the way it is, you can direct me to leave it as is. I simply raised the concerns as I saw it.
Thank you. Representative Dodge and then Representative Brennan.
Thank you. I would defer to the chair.
I would just, I'm a little hesitant to immediately say as the way it is. And I would like to ask you if you could work with Ms. Russo and other interested parties to address that issue of abuse. Would that be possible?
Yes, if the majority would like to direct me to clarify that definition of abuse with Carolyn Russo and the stakeholders, I can do so.
That'd be great.
Representative Dodge, you have another question?
Yes, going back to Ms. Risler's question about I believe it was under retaliation. I can envision that if a confidential resource person were to be extremely diligent in the performance of their duties, there might be a situation where an authority might say, might express some frustration with the level of diligence, and there might be retaliation that could be taken. In that scenario, are you more comfortable with the language as it exists?
Well, I guess first I'd say it's not important what I'm comfortable with. It's important what you are comfortable with, as this is ultimately your language. So I guess the question for the committee is, do you think it's important to keep that conflict language there, or is the importance simply that the institution may not penalize, discipline, or otherwise retaliate?
I guess I'm asking for your legal expertise, because I have seen in my years of work experience that overzealousness in one's job is sometimes not rewarded, but is punished.
I guess I should clarify what my concern or my question was. Is that sentence, the way it's phrased, it's an if-then. It says, if a conflict arises, then the higher ed institution may not retaliate. And I guess my question was, do you need the if, or do you just need a blanket statement that the higher ed institution may not retaliate? Must a conflict of interest exist before the higher ed institution is prohibited from retaliation?
Is that something that exists in labor law?
I do not know.
Then I would just say, I think I'm comfortable with the intent of the language at the very minuscule level of my understanding of labor law. Thank you.
Then we can leave it just as is.
Thank you.
That was just me. Thank you.
I'm good with it as is, Hillary, I think. I'm not seeing any further questions, any requests for any clarifications.
And then it just sounds like if everyone's sort of in agreement on those couple confidentiality pieces, that I work with your chairs to do the process through the judiciary review. Obviously, there are a lot of amendments still left to be made. I'll work on that and get that to you as soon as I can. And obviously, you'll get a final version with any potential fiscal note before it gets reported out of committee.
Thank you. And just for a heads up, just for me, I've never done it. The judiciary piece, is that something that happens soon? Is that like they're busy, we're busy, and it happens later?
Yeah, we'll most likely try to get it on the calendar for next week. I'll work with their analysts to find a time that works for everybody. The Judiciary Committee often meets slightly later than the rest of the policy committees because they do the errors bill, which doesn't come out to the very, very end of session. So they are still meeting next week, and they have permission to meet for the purpose of these sort of public records exceptions reviews. We are not the only committee that has some. So I'll work with them, and I'll work with you two to find the right time for us to get that on the calendar.
Thank you very much.
And we'll continue processing this amendment while that is going on simultaneously. So it will not hold up the amendment.
Thank you. So we'll close that work down for now. What time we have? 11:15. I am going to we have left for the day CDS language, correct? All right, so I am going to recommend a break at this time, and we have 11:15. I'm going to request a return at 12:15, please. That'll give us a chance for lunch, any necessary caucus, potentially, if you have one. And thank you. So I just remind folks, about your camera as well as your mute button. Thanks. And
Mr. Chair, are we to report to caucus, please?
let's do that first.
Or when?
Let's do that first. Now, if we could, yeah.
Thank you.
Hi, Mike.
Nice. In my official capacity, I would like to tell you, Miss Risler, that you can get a job as a clairvoyant. If things in OPLA fall through in any way, thank you very much for your help this morning. That clarified points for me and made me feel a little more confident. And I appreciate that and wanted to say that on mic. Thank you very much.
Thank you for your kind words, Representative Dodge.
You are
And-
very welcome.
Yeah. Am I to assume at this point we're still live on YouTube? Okay. So, Senator Rafferty, if when we do go back in to work session, Hillary, would you clarify for us at some point why we don't have an LD number? Because people keep asking for an LD number on the CDS bill, on the
yes.
CDS.
Yes,
Not now. When we go back live.
We are live.
Okay.
We
if
are
you want
live.
to do that. And then, well, when we go back officially into work session, I think if you could summarize the 3 reports that we have at this point, and then Senator Rafferty, I'd be willing to make a motion after that. But
Thank you.
Hillary, if you could just, even now, just since we are live, explain why we don't have an LD number.
Yes. Yes. So basically, as you know, as legislators, when you first submit like a regular bill request, before cloture, it gets assigned what's called an LR number, which stands for a legislative request number. And you don't get the LD or legislative document number assigned to your bill until that bill is actually printed as a final bill by the revisor's office. In this case, when we're working with a committee bill, it's sort of the same thing. When the committee voted on Wednesday to report out a committee bill, I submitted that to the revisor's office, and we now have an LR, or a legislative request number, for your committee bill. But the LD, or legislative document number, will not be assigned until this is reported out of committee and finally printed as a committee bill.
Okay. And do you know what the LR number is?
The LR number is 2,686.
2,686 and what?
86.
Okay.
So that means this was the 2,686 legislative request of the 130th legislature.
Okay. But so obviously we're pretty much at the tail end.
Kind of mind-boggling.
Okay.
Yeah.
So,
but yeah, so that LD number won't happen until it gets finally reported out, but you could certainly refer it to the LR number as 2686 at this point.
2686.
Yes.
Yeah. But, and the LD number will be close to that, right?
Not that close. Plenty of legislative requests ultimately get voided or duped or withdrawn or whatever. I don't know exactly where we're at on LD numbers. Probably in the 2020s-ish. I'm not
Okay.
quite sure what, you probably would know better than I of the last one you referred from the chambers.
Okay. All right, great. Okay.
If it would be helpful, I'm sure Eli or I could send out an email to the IP list when it is printed with the LD number.
It's, no, I'm okay. That I've been asked several times what the LD number is, and I say there is no LD number, and everybody says it's not possible that it doesn't have an LD number. And I try to explain because it got reported out, and it's good to know now that we have an LR number.
Yes.
And that we won't get an LD until we actually have the bill out of committee. And okay, great, thank you.
Yep. And at that time is also when it will appear and the language will all appear online.
Great.
Those two things will happen simultaneously.
Okay.
Thank you.
All right.
And procedural wise, do we just can continue with a work session, or does it have to be technically reopened?
I believe you actually already voted on it. So really today is language review.
Language review. All right, do you want to walk through that first?
Sure. So on Wednesday, you voted on the substance of the the committee bill. And it looks like at this time, unless there's sort of some reconsideration, that it's going to come out as a divided report. I had mentioned, I know it got late on Wednesday, but I had mentioned that I had to check about how that would work because there was no single report that had a full majority of the committee. That is something that is determined by the clerk of the House and the Secretary of the Senate. I spoke to Rob Hunt yesterday morning, and he confirmed that the committee can report it out as you voted it. I don't know if I have the final counts. Eli may have to or correct me if I'm wrong, but I think it ended up that there were 5 members who will be the ought to pass report. And that is the draft statutory language. So that'll be the Committee A report. And that's actually the draft language with the Department of Education had originally submitted with some revisions, obviously, and I'll go through that. I believe the Committee B report will be the 5 members who were voting ought not to pass. And the Committee C report will be the ought to pass as amended report that I believe 3 members are now on. That was proposed by Representative Millette, which I will go through today as well, because there were some clarifications that need to be made on the intent of that 3rd report. So that's how we anticipate everything will be reported out. And Eli and I will be working to make sure it works that way.
Thank you.
So with that being said, does the committee want me to sort of start with that Committee A report? There was one clarification question that came up that I think I could walk the committee through and then open it up in case there's anything else that someone may have realized was missed. It is obviously a lot and we're working quickly. What came to my attention from the Department of Education this morning, and I believe she may have emailed Representative Brennan, Senator Rafferty as well, is for those of you on the ought to pass Committee A report, I had mentioned on Wednesday that funding language, once we had stricken the actual, sort of formal funding language and just had the unallocated section about the department developing the funding formula, and there was some concern about not having anything there left in statute. So if I could pull up that section for you, the department had suggested some language on that doesn't quite work, but I do think I have a suggestion and a solution for the committee's consideration that will address this particular piece that I wasn't quite sure how the committee wanted to handle at the time. So on the, all right, so I apologize, I'm on one screen here, so everything's a little, hold on. Cancel that, second try. Apologize, I had to switch offices at lunch break because there are too many of us in our office right now and I need to be on Zoom. Okay, try this again. Okay, so this is the ought to pass report, and I'm gonna go to page 14. Okay, so this is a section specifically for the 3 to 6 year olds. And it provides, of course, that beginning July 1 of 2024, that school administrative units are responsible for child find and the provision of FAPE. And what had been stricken was that funding section. And what's highlighted in yellow here is what the department had sort of suggested in the hopes of clarifying the intent, even if that funding formula isn't currently developed and in place yet. Unfortunately, the way this is drafted is just not how we do contingent effective dates, and it would create a lot of complications because, as you know, and as we talk through, there are so many pieces of this language that needs to go in effect now. Most of it's going to go into effect now, but doesn't apply for a few years. So my suggestion, and also as we had talked about the mandate issue, would be to change this language a little bit to basically say that it is the intent of the legislature to fund at 100%. And that if funding is not provided to school administrative units through a funding formula separate from EPS, that pays SAUs 100% of the cost of education, including the pre-K education, special education, and related services for the children eligible for 619 services under IDEA, then school administrative units would not be bound by this section or would not be required to provide the services under this section. This would be done sort of under the assumption that if this all goes through and gets passed and enacted, that likely next year you're going to come back and revise this section and amend it to put that formula in. But it would sort of function as a placeholder to show the intent, that the intent is for 100% to be done through this, that if that does not happen, school administrative units would not need to provide these services. I do say this with the caveat, of course, that if that is what happens on a practical level, there are a lot of moving pieces here.
No kidding.
And so although that language would be here in the section, really, if that were to happen, I'm not sure practically what that would look like. But that would be my suggestion in terms of placeholder language, if that's the direction the committee wants to go. And then, of course, we would include mirror that language in the unallocated section, telling them to develop the funding formula to do so in accordance with this and these requirements of 100% separate from EPS, et cetera. The other little piece that the department had clarified, if the committee is in agreement, is on the compensatory services for fiscal years. They added 2022, 23, 23, 24, and 26, 27. I do believe JC Holmes is here from the department if there are questions for them.
Thank you. I see hands up already. Representative Stearns, followed by Representative Brennan.
Thank you, Mr. Chair. In our discussions, we did have some questions about compensatory services, just general knowledge. I'm wondering if maybe Ms. Holmes could enlighten us a bit on that.
Representative Stearns, you might want to repeat that for Senator Rafferty.
Oh, I heard it.
Oh, okay.
Would you like Eli to bring her in? Or
Oh, I'm sorry. Yeah, I thought he was doing that. I'm sorry.
that's okay. I think he may have been waiting for the official go ahead.
I believe she has disappeared from the Zoom call as she was being requested.
Okay, well, why don't we come back to that question? I will go to Representative Brennan and then Representative Millette.
Thank you, Senator Rafferty. And Ms. Rizzler, if I could just engage in semantics with you for a second. You kept saying, you referred to that section about the funding as intent, but clearly it states in there, it says that it must be in place. So to me, that is a stronger and more directive in saying that it's must. It's not just the intent of the legislature, it says it must be in place. Is that correct?
Yes, I do think, I mean, you can add the intent part too, but yeah, I think the idea would be to say that, you know, the Department of Education shall fund, shall do this, shall, yes.
Okay, thank you.
I do want to say though, I do still think there is very, very, very likely that this will still be flagged as a potential mandate by OFPR because the funding isn't there yet and it's not set up yet.
Correct. But again, as we've talked about before, the mandate would be of a future funding, not an immediate impact. Well, something could be funded as flagged as a mandate because there's an immediate funding impact.
Yes,
This one would be flagged because there's a potential future funding impact.
yes. Although I would also, depending on what transitions need to happen before, great, because there's sort of two separate streams of funding we're talking about. We're talking about the ongoing funding formula, and there's
Right.
also the cost for the transition.
Right. All right. Thank you.
But I'd certainly draft that language, and you would certainly see it again before it goes out to make sure it matches your intent.
Representative Millet.
Thank you, Mr. Chair. Ms. Risler, going back to the compensatory services section, did you say that section, those dates were being left in or removed?
Expanded.
So the dates are still 2022, 2023, 2023, 2024, et cetera?
Yeah, it says 2022. So I had only in my draft had 2024 and 2025 and 2025 to 2026. They corrected that to 2022, 23, 2023, 24, 2024, 25, 2025, 26, and 2026, 27.
Does that, and that relates to providing the funding for those to districts?
I would need clarification from the department on how that would work.
Can you bring up that statute, area statute again? Because my question is, if the report ought to pass includes this language, does that not seem to conflict with the effective date of 2024?
So what this says currently in the unallocated section is that the department shall pay 100% of costs for compensatory services for children with a disability from 3 years of age to under 6 years of age who have been underserved through the independent education unit model for these fiscal years. It does not explicitly say who it would pay. Presumably for the before 2024, they're pay 100% of the costs. Well, I don't know whether that be through CDS or where it would be through with the Department of Education. And then after that, I'm not sure.
Why would this be needed for 2023, 24?
You'd have to ask someone at the department.
Eli.
Senator, we have now been joined by JC Holmes. I know you had, and some others had some questions for her.
Okay. Yes, Representative Stearns did.
Thank you, Mr. Chair. JC, as our group was looking over this language, compensatory, what was the other part? The compensatory,
expenditures.
Excuse me?
I think it was expenditures.
Yes, compensatory expenditures. We have questions exactly what are those? Yeah.
Those are expenditures for students whose IEPs have not been fully implemented, that there are some services, I believe Roberta Lucas has talked to you about, that there are some children with unmet needs, and the compensatory services provision is to try and provide the additional services that are necessary to fully implement those IEPs.
Thank you. Mr. Chair, if a quick follow-up.
Yes, sir.
So let me see if I say it back to you so that you can confirm my understanding. At the present time, there are some folks in this category that are not receiving those services. And these amounts of dollars are to transition to provide them with the services, if possible, if we can find the providers, it's that type of thing. Is that correct?
That is correct.
Oh, okay, thank you very much. Yeah.
You're welcome.
Representative Millet.
Thank you, Mr. Chair. Ms. Holmes, so can you answer my question about why it's necessary to state the years of 2022, 2023, 2023, 2024, when the effective date as proposed by this report would be for 2024?
Because there are students, right, young children now whose IEPs are not fully implemented. And there are SAUs that may very well be already under contract, as if there are 36 SAUs that are under contract with Child Development Services. And if they, either themselves or with providers in their catchment area, can start to address those IEPs, we wanted to be in a position to have monies flowed to them.
So up to this point, the department has not been paying these district compensatory costs?
We are paying them for the services that they are providing. So if they are beginning already to pay for services that are on some children's IEPs, this is just making it clear that we are taking that responsibility very seriously.
So is the department currently paying these districts that have accepted Part B students, paying for these compensatory services?
Those are not, they are not Part C, they are Part B.
I said Part B. Part B.
Oh, I'm sorry, I misunderstood. I would have to verify with the finance people to clarify that specifically. We're trying to support the SAUs with any liability.
Representative Crockett.
Yes, thank you, Mr. Chair. And this question is probably more for Hillary. In the funding line on the report, did I hear correctly? There's a chance, if the intent of 100% isn't met, that some services could be cut.
So is you talking about the 100% funding that we were talking about a little bit earlier?
Yes, that you had up on the screen, yeah.
So the issue here is, obviously, I think those on this report are intending to provide 100% funding, but since you don't know exactly what that'll look like and that formula will look like, there's a desire to make sure there's something in the statutory language that reflects that that's the plan. What would happen and what this language is sort of mirroring is this issue of a potential unfunded mandate, where the state cannot require local units of government to expand or modify without paying either 90% or exempting. So this is sort of putting in that statutory language that the intent is and the plan will be to fund at 100%, even if you don't know what that is. And to capture that, if for some reason the legislature, as the appropriators, don't fund it, that your intent is that therefore the school shouldn't have to take it on.
And if they chose not to take it on, is there a way for us to tighten that up so that they do?
So this goes to what I was saying, which is essentially what I've been asked to draft is placeholder language. And I think it's the intent of those on this report that you're going to have more legislation next year to put the funding formula in place. And there's that unallocated language directing the department to come up with the funding formula and report back to the committee. As I said, if that doesn't happen, what this language would ultimately mean, yeah, I can't really say, which is why I was sort of using that intent word rather than the shall word. So as I say, I can put that in there. If it doesn't come to pass, that would be a very complicated and might be a little ugly.
Thank you for that clarity.
Ms.
It
Holmes,
certainly ties into that unallocated piece of the intent of next year, there's going to be legislation to put in that funding piece, which would likely replace what I'm drafting right now. I think that's the intent, and you can correct me if I'm wrong.
I think Ms. Holmes has something to add there.
I just received a text that, yes, there are some SAUs in response to Representative Millett's question that are providing compensatory services, and we are reimbursing them for those.
Thank you. Representative Millett.
Thank you. Because just love to keep learning more and more about CDS. It's amazing how many years into this I'm still learning about new areas of the work. Ms. Holmes, can you tell me, related to these existing
Compensatory?
yes, that's it. Thank you. Compensatory services. Is that related to any existing litigation and or federal agreements with the feds?
I would have to verify that with the staff. I'm not sure of that at the very moment. We don't have any findings with the feds at the moment.
Okay, thanks.
Thank you. Any other questions, folks? No. All right. Representative Brennan.
Thank you, Senator Rafferty. Given that there are no other questions at this point, I would make a motion to reconsider our previous action on LR 2686.
Thank you. And just Representative McCray. I think he's seconding that motion.
Yes.
Thank you, sir. That being said, if I'm correct, and I'll ask Eli, in order to do so, we would need a majority of votes from the committee to do that. Is that correct?
I believe so, yes.
Yes.
Okay, so the motion's been made and seconded. Is everyone clear on the motion to reconsider? All those in favor of reconsideration, if you would be kind enough to hold your hand up, wave it into like your face on the screen, so I can see where we're at. 1, 2. 6, 7, 8. I have 9 visible hands. Any against? Please raise your hand and hold it so I can see it. I have 2. So of the 11 present, it is 9-2 in favor of reconsideration. The motion to reconsider carries. Representative Brennan.
Thank you, Mr. Chair. I'd like to make a motion at this point. Ought to pass on LR 2686. I'm trying to ought to pass with the language that Ms. Risler just highlighted in what had been a previous report. But in regards to compensatory, right, compensatory, I'm sorry, compensatory, and the full funding language.
Thank you. Representative Dodge.
I would second that motion if you are referring to committee amendment A, I believe.
Yes.
We are in reference, yes, that so we are motion's been made and carried. I'm sorry, and seconded. I'm sorry, Representative Hillary. Hillary.
just want to clarify, because I know this is so confusing, but it will be committee report A,
right, okay.
But it will come out of committee as ought to pass, because it's your report is the original bill.
Right.
So relative to committee report A,
Committee report.
We are under reconsideration. That said, I think I'm at a step where we need to call the roll for the full committee. Eli.
On a motion of ought to pass for committee report A of LR 2686, Senator Rafferty.
Yes.
Senator Rafferty votes yes. Senator Daughtry. Senator Daughtry is absent. Senator Woodsum.
Yes.
Senator Woodsum votes yes. Representative Brennan.
Yes.
Representative Brennan votes yes. Representative Crockett.
Can you pass?
Absolutely. Representative Dodge.
Yay.
Representative Dodge votes yay. Representative Lyman.
No.
Representative Lyman votes no. Representative McCray.
Yes.
Representative McCray votes yes. Representative Millette.
No.
Representative Millette votes no. Representative Roach.
No.
Representative Roach votes no. Representative Salisbury. Representative Salisbury is absent. Representative Sampson.
No.
Representative Sampson votes no. Representative Stearns.
Yes.
Representative Stearns votes no. Representative Crockett.
Excuse me, I voted yes.
You voted
Oh,
yes.
my apology. I wrote down yes. My apologies. Representative Stearns votes yes. Representative Crockett.
Yes.
Representative Crockett votes yes. Including a yes vote from Representative Stearns. There is 7 yes and 4 no, with 2 absent. Is there a single minority report, or are we still?
I
Have
still am offering my report with the amendments that Ms. Risler has.
I am an ought not to pass, period.
Thank you.
Hillary?
And Representative Roche and Representative Lyman, are you on the ought not to pass with Representative Sampson? Okay. And then I do just quickly, if I could, unless there are questions, briefly go over Representative Millette's minority report. She had provided a clarification for me yesterday from what I had originally drafted. And so I just want to make sure we put that out in the open as well.
Yep.
This minority, and Representative Millette can correct me if there's anything I missed from her clarification, but the biggest part is that it was her intent that while the Department of Education would hire the outside facilitator, it would be the outside facilitator who would actually convene the task force and report back to the committee. So this clarifies that the department shall hire the outside facilitator no later than 60 days after the effective date of the resolve, and that the department shall use existing resources designated for the transition or reorganization of the provision of services to hire the facilitator. The facilitator then is tasked with convening the task force no later than 30 days after being hired. It adds 2 members from the Department of Education, 1 representing Part C and 1 Part B. All the other members remain the same. And then the duties, I think, are all the same as what was said and what was sent to you yesterday. Oh, sorry, and then it adds similarly that there would be status updates and that the committee could meet to receive the October status date.
Representative Millette.
Thank you, Mr. Chair. Just a couple of points for clarification. The task force would be the one reporting back to the committee.
Okay.
Right, not the facilitator.
Yep.
There's language, I believe Hillary said this, about using existing resources. I referenced that because the department included in its report to the committee that it has a planned position for a project manager for the transition. So clearly they have made space available in their resources for somebody of that nature. And I would imagine that they probably already have the RFP underway. Thank you.
Hey, anything else, folks? So just, oh, yes, Hillary.
Thank you. I would just mention quickly, of course, obviously this is a preliminary draft language review, and as it goes to the revisor's office, I would ask permission, especially since the committee will not be meeting regularly, that if there are any technical questions or concerns that are raised, that I could share a draft with anyone as needed, including the chairs in the department. to resolve any questions. If there's something more substantive, I'll obviously bring that back to the chairs. But then ultimately you will see this again with any potential fiscal notes before it is reported out of committee, at which point, as I mentioned, at that point, it will finally get the LD number.
Okay. And Senator Rafferty, if I could just, we are meeting next Wednesday to do confirmation hearings and to do priority setting for the committee. And Ms. Risler is preparing a list of that have fiscal notes and budget issues that we would consider next Wednesday for priority setting. And I think Senator Rafferty, Senator Whitsom, and Representative Stearns and myself will try to talk about how that priority setting process will go forward, so that we can have some guardrails on Wednesday.
And that'll follow the confirmation hearings.
Right.
And Eli, just to confirm, because I know today is the so-called last day, in terms of registering the vote, could you make sure that Representative Salisbury and Senator Daughtry have that information? I'm not sure if this is still open till Tuesday at noon or what it is. So just as long as they're aware of the limit, I'd appreciate that. Thank you.
Absolutely.
In the meantime, it's going dry. Thank you, folks, for your work. I know it's been a long week. We've had a lot to do, and I appreciate everyone hanging in there and doing it. Eli and Hillary, I know you've been on overload. I think we are all feeling that. And from what I've been told, there's more to come, but we'll make it. So hang in there. Enjoy your weekend. Have a good day.